So thanks to IOM and to everyone here in the room and out there in the ether for shedding the light on this very important, if somewhat geeky, issue. So, you might not know the painting, but I'm sure many of you recognize the style. It is abstraction of stream, and it is the painting that greets you as you enter Georgia O'Keeffe's museum in Santa Fe. And as you look at the painting and you look at the wall behind you, you will see O'Keeffe's words. It is only by selection, by elimination, by emphasis that we get at the real meaning of things. Here's another abstraction of stream using a technique called hierarchical Bayesian modeling. I am investigating the relationship between charged particles and oxygen in two streams about 7 miles north of here. And I'm particularly interested at the inflection point at which oxygen begins to go down, which is represented by these two arrows. And I do this, yet I know that if I had selected other data, if I had eliminated some variables or emphasized other equations, I would have gotten different inflection points or perhaps no inflection point at all. Now, if these models remained on my laptop, they continue to be an interesting intellectual exercise. But the moment I use any of these models to make a decision that affects other people's lives in a significant way, that's a problem. Liz Fisher at Oxford University, Wendy Wagner at UT Austin, and I have written a series of papers looking at the problems associated with using models to make regulatory decisions. Our first paper we wrote simply to impress upon the legal community that models are everywhere, they're ubiquitous. Any major regulation that is issued by the Environmental Protection Agency is ultimately based on the model. And as people like Ross have pointed out this morning, everyone uses a model. If you use a Fitbit to track the calories you've burned today, if you use a Google search, you've used a model. The second paper we wrote to simply highlight the fact that litigants will challenge models by pointing and mischaracterizing models as belonging to two different extremes. They're either truth machines, in which case, the moment the model makes an error, that invalidates the model. On the other extreme, they're completely malleable and therefore arbitrary and capricious under the law. Of course, the truth is in between. There are indeed model uncertainties that prevent us from making perfect predictions, but there are evaluation methods that help us to distinguish between models that are truthful and models that are merely truthy, to borrow from Stephen Colbert's lexicon. So there is no such thing as a free lunch when developing models. Every modeling approach has its own intellectual foundation, its own set of assumptions, which I refer to as an epistemic frame. In 1962, the Food and Drug Administration, in response to the thalidomide crisis, stated by way of regulation that the best scientific evidence in terms of evaluating drug risks are randomized clinical trials. Implicit in that is the fact that it is actually prescribing one particular approach, one particular statistical method to draw inferences. And over the years, a number of panels, including those organized by the IOM, have been recommending that FDA take a more agnostic view of modeling. And it took the Vioxx crisis for the Congress in the FDA Reauthorization Act of 2007 to prompt FDA to take a more universal view of modeling and to basically say, we're going to use all the information available. And so we used the FDA Reauthorization Act of 2007 to make the case that what is necessary is you have to be transparent, not just about your modeling methods, but about those methods' epistemic frames, and you have to use those epistemic frames in a way that is appropriate to the particular system that you are trying to model. Our fourth paper will be coming out next month, and in that we talk about how model transparency leads to both legal accountability and defensibility. And we talk about that within the context of the Clean Air Act, which is rather complex, but for today, there are only four things that you need to know. First, when implementing an ambient air quality standard, they have to protect public health. They have to be based on the latest science. They have to be reviewed by a science panel. And they have to be subject to judicial review. What does the fourth point mean? It means that if you are a stakeholder and you can establish standing, if you disagree with the model that the agency uses to make its regulatory decision, you can haul the agency into court and force the agency to defend this model. Now, you can imagine then that over the years, we looked at the 45-year history of ambient air quality standards, and we analyzed 16 cases. And there were many litigants who disagreed and filed a lawsuit against the agency. And during most of those years, the courts took a very ad hoc approach to evaluating science. It was very much reminiscent of Justice Stewart's statement regarding pornography. We don't know what good science is, but we know it when we see it. And so it was very confusing, and if you read the cases, they're rather incoherent and not very cohesive. It was not until 2008 when EPA finally took the modeling bull by the horns and said, all right, here is our epistemic framework, and if you are going to evaluate our science, evaluate us against this framework and against this approach to modeling. And what is that epistemic framework? Well, let's start with this statement, which is the baseline. The DC Court of Appeals, citing one of EPA's documents in a case called Mississippi versus EPA 2 years ago, made a statement that controlled human exposure studies, like the randomized clinical trials, engender the highest level of confidence about going to the question earlier, causal relationship between ozone exposure and health effects. And that certainly comports with what we remember from high school. Here's X, here's Y. How does X cause Y? Let's hold all the other possible variables fixed. If I wiggle X, will Y wiggle as well? If so, that's a very good case to be made that there's a causal relationship. And as Ross pointed out this morning, for ethical reasons, we cannot randomize different groups and expose them to different concentrations of toxics. We do not have multiple planet Earths where we can hold things constant except for varying concentrations of greenhouse gases. Therefore, what EPA did is to establish a causal framework. Perhaps, and that's why we use modeling, perhaps there's a way analytically, computationally, to control for some of the other covariates that might interfere with the pure causal relationship that we all are acquainted with. So, depending on the degree to which we can control covariates, then the studies that we look at are either causal, likely causal, suggestive of causal, and perhaps we even have evidence of absence or absence of evidence. So what do we do with these different studies? Well, we look at the studies that are categorized as being causal, likely causal, or suggestive of causal. We look at the different endpoints that these studies have shown to us, and we look at the pollutant concentration at which they appear, and we understand that these are just averages that represent the distribution, and because of the way the Clean Air Act is written, we are mandated to protect the most vulnerable population, and so we choose the 10th to 25th percentile to establish our standard. So it's the big difference here from the way we used to think about science is, okay, rather than having X and Y, what we're really talking about is we have X and modeled Y. And so it's important to look at the modeled values of Y, our hypothetical causal relationships, and use the distribution to figure out whether the data and the evidence are actually telling us what we think they're telling us. So distributions, the way that I approach modeling, are very important, but it's a very abstract term. It's hard to wrap our minds around distributions. And a very helpful way to think about distributions is to think about the Galton box. Francis Galton developed this gadget in the 1850s. He was a second cousin to Charles Darwin, and it's just a row of pegs, columns of pegs, and you drop pellets at the top. And even though the pellets seem to drop in a haphazard, random fashion, lo and behold, at the bottom, you have a shape that can be approximated by the normal or Gaussian distribution, the iconic bell curve. So for Galton, his gadget was important in multiple ways. First, it was a physical model, a tangible object that represented a mathematical form. That mathematical form, in turn, was a model for a physical reality. It helped Galton to understand evolution. So there was this thing that he called organic stability, forged by years and eons of evolution. And there was variability around that organic stability. And though Galton could not precisely describe the biological mechanisms that formed a person's height, weight, or intelligence, he knew that in the aggregate, he could measure these things, and at the population level, he could use these distributions in ways that were useful. In Galton's words, models may never be exactly correct in any one case, but will always be approximately true and serviceable for explanation. The statistician Dave Box said it more pithily in words that are near and dear to every modeler's heart. Every model is wrong, but some are useful. When EPA's former science advisor asked me to deal with models, his directive to me was build the black box out of plexiglass. And I've come to realize that that is not enough. When the stakes are sufficiently high, the model should be accompanied by an infrastructure. So we provide you model evaluation paradigm, a way of evaluating the models that are consistent with what we think the intellectual foundation says about our system. We have an expert panel, a science panel, to evaluate that because we think that perhaps the lay audience might not be able to evaluate it, even though we provide that yardstick. And it is important that even the formation of the expert panel is transparent. So we inform people how they're going to be formed. We give them the opportunity to participate. So even the formation of the expert panel needs to be transparent. And we will know that there will be stakeholders who will try to use science for their own purposes. So we have the court to keep us honest and to serve to filter out values-based interests from legitimate science-based interests. Now, one might think that it is fortunate that we have this statutory construct, but it glosses over the fact that EPA actually installed some of the elements of this infrastructure before the statutory mandate and has gone beyond the statutory mandate. So what I'm suggesting is that if the stakes are high enough, one can certainly enter into memoranda of understanding to establish science panels or arbitration panels to do what we do because we are required by statute to do this, and therefore reach important decisions despite the underlying uncertainties in a model. And with the term uncertainty, I'd like to end with the words from a scientist whose name is intimately associated with uncertainty, Werner Heisenberg. And it is ultimately a plea for humility. He says, what we observe is not nature in itself, but nature exposed to our method of questioning. And at the end of the day, that is how I view models. It is nothing more than a formalized method of questioning. And I'm there.